topics and opinions expressed in the following show are solely those of the host and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert Show on W4CY Radio and Talk4 TV, where we bring you educational information from experts on such topics as legal, health, financial, and home improvement. Now sit back and listen to our experts in community association law, estate planning law, tax relief, Medicare, public insurance adjusters, neuropathy treatment, business brokers, and personal injury law, along with many other topics. Now here's your host for the last 17 years, Steve O.
Orlando, Florida. Welcome to another live Ask the Expert show where we bring you the top experts in the field of legal, health, financial, and home improvement. We are live on 70 platforms. We are also live on TikTok right now. And our show today, listen, if you live in a condo or an HOA association, you don't want to miss today's show. I got to tell you, people have more questions when it comes to their association. And I got this show, Kay Bender Rimbaum, has been airing with us for 15 years. That is amazing. And our audience, believe it or not, still grows every month. Let me introduce you to a gentleman I call a friend. He makes the show so easy to do. Let me introduce you to board certified. I love saying that. Board certified, Alan Swartzide.
Hey, everybody. Thanks, Steve.
I love saying that.
I think certified. You're more excited about that certification.
I am.
At this point. And you know what? I'm fine with that.
Well, you know what? Let's tell people how many board certified attorneys are there in the community association law.
I know it's under 250. I'm not sure the exact number at this point, but in all of Florida, I think it's around 200.
So I have every reason to brag on you. Alan, I got to tell you, I'm going to share this on your show. When I was, and I got this from a sports athlete who said he always loved watching basketball, wish he would play in the NBA someday, and he got his wish. He's playing in the NBA now. And I was thinking about, at 10, 11, 12 years old, I used to watch a show. It was called Ask the GM. And it was the GM of a ABC TV station. And I thought that was just the greatest show. I watched it every week. I didn't care what the questions were. And here I am today basically doing the same exact thing. So you never know. Hey, Alan, we've got all these new people joining us from TikTok. Tell us about Kay Bender Rimbaum.
Well, I mean, we're a law firm that's been around since I think it was 93, but early 90s for sure. 27 attorneys practicing exclusively in the areas of community association representation. So we represent condos, HOAs, co-ops. It's pretty much all we do other than my mediation practice, which is largely and pretty much exclusively centered around community associations as well. Same thing with Jeff Rembaum's mediation practice. Some of the expert testimony we do, but again, HOA and condo is all we really focus on. 4 offices, including the one that I manage here in Winter Springs, which is basically East Orlando, another in Tampa, one in Palm Beach Gardens, and another in Pompano. And 9 of the attorneys, as Steve mentioned, within the firm are board certified specialists in this area of law. That includes me, and then another board certified in condo. So we're not trying to take you away from your existing attorneys. We're just trying to help you out by being on the show today. But if you're not happy with your attorney, or you need a second opinion, or you just need someone who's going to be able to step in when your attorney is frankly taking too long to get you an answer, we're happy to talk to you if you're open to a discussion, is the way I'll put it.
Your firm offers more free educational classes than any firm I've ever heard of. It's amazing all the different classes that you have every month. And basically, this is like a class. You all do I think it's Ask the Lawyer or Ask the Attorney.
Yeah, Ask the Attorney is in person.
Yes. And I actually went to several of them, and I was watching people who were in the audience. There was about 50 or 60 people in there, which I was told is a pretty good size. And I heard a man say, I've got one question and then I'm out of here. Alan, I got to tell you, he ended up asking about 12 or 15 questions, and he stayed for the whole thing.
Well, and I will say frequently when you start educating people, they don't realize what they don't know. It's
Yes.
the old, you don't know what you don't know until you know. And in reality, that's part of the reason we do so much education. Frankly, it becomes easier to give guidance to our clients if they've already learned the basics from these classes that we're teaching. Some of them go into a little bit more advanced information, don't get me wrong, but the reality is also that if a client has watched, for example, the collection class I'm teaching tomorrow, chances are half their questions will be answered, some new ones will pop up, and we can give, an explanation that doesn't need to be, I'll put it this way. We don't have to give the third grade education level answer. We can give the college education answer. And that's part of it's one of the reasons that I think that the education that we provide without charging is so crucial, because without that, a lot of our clients, they've never run a business before. They're running blind and they have no idea what they're doing. And hopefully they took at least their board certification class that they're now required to take, and maybe some other classes throughout the year. But, that is a big part of why we provide the education we do, because without it, you got to pay your attorney to get every single answer. And if your attorney is knowledgeable enough, a lot of the answers that we give, just like everything we're going to do today, is just off the cuff based on existing knowledge. It might be that I have to go in your documents to answer your questions, but I'd say at least 60 to 70% of the questions I get on a daily basis, I have people texting me and I'll answer them, because it's such a straightforward, I have the knowledge. Why not share that knowledge? So I'm going to jump off my soapbox and let you talk now.
No, your soapbox is always right on. I got to tell you, I don't know, are elections, does each association have a different time of the year they do their elections?
There's the fairly standard towards the end or beginning of the year, but yes, every community, usually the governing documents and primarily the bylaws, will tell you when that election is supposed to be held. The ones that I like best are the ones that say it's going to be within this 3-month period, so that you're not constrained to the third Friday of every January at 6 p.m. I'd much rather not see those really strict provisions in governing documents, because frankly, it just becomes a pain to try and make sure that you're able to find a location that isn't going to cost the association a bajillion dollars to rent out if you don't have a clubhouse that's big enough to house everyone.
I have to do this now that we're on TikTok. If you enjoy the show, give us a tap on the screen if you like it. Please follow us. We don't ask for any gifts. 5 people have asked the same question. We're getting ready to start our elections that's why I asked you this, in the next coming months. They want to know, do you have to have a certain background? We get this a lot. Do you have to have a certain background to become a board member?
No, not at all. I mean, there are restrictions in the Florida statutes that limit who can be a board member. Now, your governing documents may say whether or not you need to be a member, but the statutes basically say anyone that's a member of the community, meaning an owner of property in that community, can serve on the board. There are no qualifications in advance other than you don't owe a bunch of money to the association. You don't have a felony on your record that hasn't been cleared up in the last 5 years. There's a specific legal term, but I won't waste your time with it for what that looks like. and you haven't gotten hit with any HOA or condo crimes that are still pending or that you got convicted of. So other than that, there's very little that's going to keep you off the board. There are things maybe that'll make a better board member, like someone who's been involved in the past in the running of an actual business. But beyond that, I mean, listen, I know plenty of people who do a better job of being on a board than people who ran a business into the ground.
Wow.
You know, I mean, just because you've been involved in business before doesn't mean you're any good at it. So the bottom line is, if you're interested, you care about your community, and you can make decisions that are not emotionally charged and are business decisions for that corporation, to me, that's good enough. There's no specific criteria.
You know, I think I've shared this with you before. Everybody, because we've got such a huge mailing list, everybody writes us like we're the authority, which there's no way. But listen to you guys for as long as I have, I've learned so much. But people have concerns, they have questions. And one of the things we do, we give them your phone number, we give them your website address, but we tell them, you know, if you've got complaints about how the system works, go ahead and run for the board, right?
Right. Yeah, I mean, frequently, if someone's in a board meeting or a member meeting and complaining about the way things are going, my response is, okay, well, the election's coming up, run for the board. Exactly what you said, Steve. And frequently, if it's, oh, well, the landscaping isn't being taken care of, and there's a landscaping committee of this association, okay, well, sounds like we've got our first volunteer for the landscaping committee. Or if there isn't one, well, you know what? Sounds like this person wants to be the first member of a new landscaping committee. Board, do you want to create one now? People that care enough to show up to a meeting and complain are probably people that you want to at least have some voice in the community. Now, don't get me wrong. You know, there's always one, is the way that I'll put it. There's always going to be one curmudgeon who's going to sit there and get off my lawn. But the bottom line is, most people that show up to a board meeting, it's not because they want to bitch at the board. It's because they care enough to show up.
You know, we used to get so many questions about pets, and it's been replaced. You're not going to believe what it's been replaced with is outdoor cameras.
Yeah, okay. Fair.
Here's Mark in Orlando. He said, did I hear on one of your shows correctly that placing an outdoor camera to the exterior of my home in an HOA could be considered material alteration violation?
So that's conflating and combining two issues we've discussed probably 10 times on the show. So what we've discussed regarding these exterior cameras, one, when you're talking about a material alteration, that's literally just any change to the appearance of the buildings, the appearance of the common areas, common elements, and whether that would require any kind of member vote, whether it's a problem in any way, frankly depends. First of all, are you in a condo? In a condo, a material alteration requires a vote. In an HOA, it usually doesn't, unless there's something in your governing documents that says it does. So I don't know where Mark is located other than somewhere in Orlando, but whether it's an HOA or a condo makes a difference when it comes to a material alteration. The other thing we have discussed, and I remember this distinctly, is that if it's pointed into an area where privacy should be expected, not the exterior of your property, but like your backyard where you have a fence and you expect to be able to, let's say, sunbathe, for example, or you expect your kids to be able to play in the backyard without someone else being basically videotaping it. There's something called a reasonable expectation of privacy. And if you've got that expectation, then your neighbor or your community association really shouldn't be pointing that video camera at a place where you've got that expectation. Now, out on your front lawn, when you don't have a fence and there's nothing blocking the view from the street, there's no expectation of privacy. You may have specialized rights when it comes to being on your property, but pointing that at the front of your property probably is not a violation. Pointing it where if you open your door, it sees inside, yeah, that might be a problem. Pointing it into your bathroom window, definitely a problem. So it really just depends on the context as to whether that's problematic in and of itself. And I know, Steve, just before we even get there, that I saw one question that was submitted in advance in writing regarding signage for these video cameras. So I'll go ahead and answer that one now. The question, and I apologize to whoever asked it. I appreciate the question, but I don't remember whether it was, who it was. But it was, are signs mandatory when you're going to put a video camera in a public area in a community association?
Yes.
The answer is no, but it'll probably protect the association primarily because, and I actually have an entire class on this subject, as obnoxious and frankly uninteresting as that may be. But I've put together an entire class, and one of the things that I point out during that class is if you put up signage that clarifies, we're not recording this 24/7, we're not monitoring this video footage 24/7, it's only available and written over every X amount of days, then you're protecting the association from the unreasonable expectation that you are protecting people by having these cameras. If the purpose is not to record and monitor 24/7, my opinion is if it's an association property where that camera is posted and not an individual lot or unit, then there should be signage just to protect the association, even if for no other reason.
This is Reed in Orlando. He is an HOA. He said, our board just passed a special assessment for major clubhouse repairs. Okay. One of our owners believes that the governing documents require an owner vote. The board disagrees. What are the owner's options?
Well, the owner might be correct. They might be wrong. The reality is, if your governing documents require a vote, then my opinion is the board should try to get it. Whether the board is obligated to get it might be a different story, because there's case law in Florida that essentially says even if you're supposed to get a member vote, and by the way, I don't want anyone relying on this and not getting an opinion from their own counsel when it comes to this issue. But there is case law in Florida to the effect that if it's a repair or maintenance obligation of the association, the members can't stop the association, stop the board from complying with its legal obligations by not voting in favor of a special assessment. So you might have the authority to push forward that assessment even though you didn't get the member vote. You might have the authority to spend the money even though you didn't get the member vote, if this is an obligation of the association. Again, part of the reason that I suggest you get an opinion, on this from your attorney is, I guess, threefold. First of all, you want to know that your attorney actually even knows about this case law. If not, it might be time to talk to a different one. More importantly, you want the backing of having relied on advice of counsel. Nothing I say during this show is advice from your counsel, even if I represent your association. You want to be able, if the association or any of the individual directors are sued, to write back and say, we relied on advice of counsel. We made this conscious decision on, to make sure to perform the business needs of the association. But at least if you've asked your attorney for that written opinion, whether or not you're going to disclose that as a privileged communication doesn't matter. At least you've got the ability to say, we relied on advice of counsel, not I watched a radio show a year and a half ago and some guy whose name I don't remember said that I could do this. Which frankly, you might or might not be surprised, Steve, by the frequency that I will get someone who searches on Google Esquire or ChatGPT Esquire, comes up with an article from 15 years ago and says, well, Alan, I think you're wrong because this article says otherwise. First of all, that article wasn't necessarily written by someone that knows what they're talking about. Second of all, that article that's 15 years old isn't necessarily still good law. So just be careful relying on, listen, there are some great attorneys out there, my partners included, who put out articles on a regular basis, know what they're talking about, and get it right. There are some other law firms that do as well, but there are also some people out there that are not even attorneys and are giving informal legal advice without giving legal advice so that it's not the unauthorized practice of law is the way that I'll put it. So just be careful. Think about the source of the information you're getting before you start to rely on it. And more importantly, before you start to tell someone else, whether you're attorney or anyone, that they're wrong based on one article from a couple years ago.
I like the ones that call up and say, my friend told me that this is truth, or my family told me. Listen, when it comes to the law,
my uncle, who's a family lawyer in Texas, told me that you're completely out of your mind. Okay, good for that.
That's right. So let me get this question in before we go to your schedule coming up and our break. This is from Cheryl in Winter Park. Well, I've never had a question like this before. If a board member has a disability like they're deaf, can they effectively sit on the board as a president?
So I don't know if I heard you correctly. If their death occurred and they're deceased, they can't serve because they're dead. If you said deaf as in can't hear, which I think was the question, no, that's not a basis to keep someone off the board. And in fact, you might be violating their rights by discriminating against someone just because they're deaf. Many, many, many people who can't hear can still communicate just as well. You just might need to give them an accommodation to be able to communicate in a different way if they request it. That might be, they text to talk. It might be that they use sign language with an interpreter, or sign language and you can interpret for them. There are a lot of ways that someone who cannot hear can still actively and appropriately participate in the operation of a community association and any other business for that matter. So anyone who is precluding someone from serving on the board just because they can't hear, or even has very bad hearing and refuses to get hearing aids, most likely is discriminating against that person and could be hit with significant penalties that, frankly, I wouldn't want any of my clients getting into. Understand also that when someone brings a claim like that, usually they're not paying their own attorney's fees. It's the government coming after you. And even if you win, unless it's bad faith to have brought the claim, which the description that you guys gave in this question, that won't be bad faith. It's a valid claim potentially. You won't get your attorney's fees back. So you spend 50 grand to win and you still lose because you're out the 50 grand. So again, jumping off the soapbox here, but be very careful with discrimination claims. They're not something I'd mess with.
Alan, let me tell you something. You are one of my few experts. You can go on for as long as you want. You have my permission.
I'm going to tell you, Steve, that we will lose listeners if you give me that permission, because I won't shut up.
Well, speaking of losing listeners, I have to tell you this. We have, and we're going to have you do the schedule, and then we're going to go to break. We've got right now 2,400 and change likes so far. So I don't think anybody's going anywhere.
Okay. Well, I appreciate every one of them.
Let's go to your schedule.
All right. Well, tomorrow I'm actually teaching a class for the firm with Empire Management. It's going to be on collection of assessments. We'll get into some mortgage foreclosure and bankruptcy suggestions of maybe some delays that might pop up and how you might deal with those. There will be a Q&A as always during that class. So that's going to be tomorrow. And all of these, by the way, you can register, no charge, as Steve mentioned, at kbrlegal.com on the calendar link at the top in the middle. On August 11th is the next one we've got on the calendar. That doesn't mean it'll be the next one we teach, but HOA record keeping and records access, that's going to be taught by Emily Gannon in our Pompano office. August 12th, the next day, screening of potential residents and buyers in your community. That's going to be taught by Chris Posner in our Pompano office. And August 21st, we have our Back to Budgets event. That's actually going to be me teaching legal update in Winter Park. That is a very, it's not a firm event. It's a firm sponsored event with, I think it's 12 other vendors that it's kind of going to be a small trade show with a couple classes that we're offering. So if you're interested, we should be posting about it very soon, but feel free to reach out if you're interested in joining us for that one. And then finally, the last thing on the calendar as of now, through August is August 21st. Kirsten Henza out of our Tampa office will be teaching an HOA board certification class. I believe that one's with Empire Management as well. We should have a condo certification class coming up the following month, but I'd be surprised if we don't have a couple other classes added by the time that August actually rolls around in a couple days.
We're going to go to a break. Before we do that, tell people how they can reach your office, Alan.
Sure. Well, if you need to reach me, and again, only HOAs and condos and co-ops, but my email address is as@kbrlegal.com. KBR is in K Bender Rembaum. You can also reach anyone in the entire firm at 1-800-974-0680. Again, 974-0680.
We're going to go to a break. We'll be right back with Alan Swartzide.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your host, Steve-O, and his expert guests.
And we are back. This is the Ask the Experts radio show. We're on 70 platforms, including TikTok. We've got my great friend, board-certified attorney, Alan Swartzide. Look, he still laughs. He still smiles. Sounds better when it comes from somebody else. So, Alan, we've added a lot of new people, and you've got an amazing schedule coming up. I got to tell you, I deal with a lot of community association law firms across the country. And K. Bender Rembaum is one of the few firms that really just concentrates on community association law. Most of them, you'll see, I call it a shingle because I'm so old, but they'll say bankruptcy law, criminal law, personal injury, business, and community association law. Let me tell you something I've learned over the years. When a firm just concentrates basically in one area, that's who you want to go with. How about that, Alan?
I can't disagree. I might be a little biased, and I will tell you, you can use the word shingle. I use the phrase door firm because if business comes in the door, they'll take it. Yeah. I never wanted to be that. I wanted to make sure that if I'm going to take on a case, I was just discussing this with a colleague at lunch the other day. Neither one of us will take on a claim or a case or a client that we don't fully know how to help. If it's a situation where, we just need you for a real estate deal, I'm referring that to somebody else because I don't ever want a client to have to pay for me to learn how to handle their situation. I want to walk in the door and say, okay, well, I need to do a little research, but I know exactly where to look. I don't ever want it to be, I have no idea what the hell you're talking about. I don't know how to help you, but if you pay me enough, I'll figure it out. Not how we practice, not how I ever wanted to operate. And that's why I came back to work with KBR it's 4 years ago next month. Wow.
Let me go to Gene in Orlando. If an association has $1 million in reserves for painting and consulting, and a consultant comes up with a plan that costs them $800,000, does the remaining $200,000 stay in reserves?
So the answer is yes, unless. And that's not a lawyer answer. It's not a, it depends. The answer is yes. But if you want to use it for some other purpose, if you're in a condo or an HOA, probably doesn't matter. It just depends what vote you'll have to get. But you would need a vote of the members to use those funds for any other purpose, unless they're in a pool with a bunch of other assets. So the shorter answer is, yeah, you just have 200 grand left.
Okay. Lori in Orlando, any advice for me? I'm in an HOA, filed for mediation, rejected attorney's choice of moderator a month ago, but haven't heard back. What do I have to do to move forward?
Well, if you're an owner who demanded pre-suit mediation, you were the one that was supposed to point out 5 mediators that you're willing to use, and they're supposed to select one of those. If you didn't send your demand to include those 5 mediators that you're willing to use, it might not be a valid demand, and they may be looking at it as, no, we don't agree to your demand because it's not legally sufficient, but we'll mediate if you're willing to use these mediators. I would suggest, frankly, based on what's been described, that you might want to talk to an attorney that knows this area of law and practices this area of law regularly on the owner's side, that can give you at least the minimal guidance of whether your letter was sufficient or not. If the letter's sufficient and they didn't agree to mediate with one of the mediators you selected, you can maybe just file your lawsuit. But again, I would consult with an attorney before you ever file a lawsuit.
Alan, I've learned from doing this show that homeowners that are in an HOA association and homeowners who are in a condo association talk to each other. Here's Jill in Lake Mary. Why can condominium owners file complaints with the state of Florida? Why homeowners living in an HOA often have no state agency to turn to?
So there may not be a state agency. That doesn't mean there's no recourse. It just means you go to court instead. And the reason is that one of the first things I explain when I'm explaining the difference between an HOA and a condo is exactly this answer. Okay. So the answer is essentially that HOAs are creatures of contract. They exist not because there's a statute that says they exist, but because you've got your declaration, your covenants, and those are recorded against each lot that is contained within that HOA. A declaration of condominium couldn't really exist without a statute to support it because of the way you're subdividing air. You're just splitting up the air based on walls that you've arbitrarily created. So the condo statute is the reason you can have a condo. And because of that, there is a lot more regulation by the government of condos than there is of HOAs. If you look at the two different statutes, I don't remember the last time I looked, it was about 130, 140 pages for the Condo Act. The HOA Act is 20 or 30. So there's just a lot more government regulation overall of condominiums. Again, it doesn't mean that there's no regulation. It just means that if there's a violation of a statute or a violation of your declaration or some other rights that are not in either one specifically, you go to court. Now, you may go to pre-suit mediation before you go to court, like the previous person asked about, but you go to court instead of having the government decide something and then potentially have a court decide that they were wrong. So frankly, yes, arbitration, which is the DBPR, the state agency you're talking about here, it might be less costly, but it's less consistent in my experience. Precedent is not always followed. So owners will routinely go there hoping that even though they're not 100% sure whether they're correct or not, they at least have a better chance. Unfortunately, that's not an option for HOAs because the statutes simply don't say it is. The statutes don't give jurisdiction, meaning the power to adjudicate any of these issues, to the government. In a condo, the opposite is true. Most of what a condo does can be regulated by the state agency, the DBPR. So that's the long answer.
This is from Keith on YouTube. I am really enjoying the show. I was hoping just to come on for a few minutes, and you've definitely got my attention. I'm curious, what is the difference in what your firm does and what a management company does?
So we are two different sides of a similar coin. The management firm is going to do all of the in-house work. They're basically going to take care of the accounting, the books. When I say books, I mean the official records as well. They're going to do the job of the secretary, the treasurer, and some of the other officer roles. They're also going to be the point person for a lot of the business that the association actually does. They're going to talk to vendors on behalf of the association. They basically take on a lot of, again, the officer roles of the association. Our role as a law firm is to handle the legal aspects of those things. The things that require an attorney or require legal guidance that someone who is not a Florida barred attorney is simply not allowed to do are the things that we handle. So management, for example, may be able to send out a couple demand letters, whereas they can't send out an offer for pre-suit mediation because it's a legal analysis and a legal letter. They can go ahead and send out a notice of late assessment for someone who doesn't pay their assessments, maybe an intent to lien, but they're not allowed to record their own lien. They have to hire an attorney to do that. Some management firms have an attorney that they work with sort of in-house that does this on a bulk and therefore cheaper basis. Some don't. But at some point, regardless of what that attorney does, when you're filing your lawsuit, you get to select your attorney. That's us. At least I hope so. So the difference is management handles the business side of the association. We handle the legal side of the association, at least the ones that we represent.
Kathy in Orlando, I've got to figure out what her abbreviations is. If a current board of director member hits the 8-year term in a year and a half into the second year term, is he or she automatically off the board, or does he or she get to finish that term before being termed out?
So what we're talking about here, I presume, is a condo statute that went in place in 2018. Yeah, it had to have been. It was a 2018 statute that basically said you can't serve more than 8 years consecutively as a condominium director in Florida. And the question that was asked a little, maybe more succinctly, is does that cut off the director's service at literally any time, even mid-term? Or is it that they just can't run again after the 8 years is up? My opinion and what DBPR has told us, and again, DBPR is the state agency that governs condos. So if this dispute about whether or not someone's still on the board were to pop up, that's probably where it would end up in DBPR arbitration. They've said that it is essentially you finish out your term, and once that term is done, you can't serve again until you've no longer served consecutive years. Now, there is a loophole in the statute. I'm not going to talk about it out loud, but the bottom line is you can drop off the board and it's no longer consecutive. There was an attempt to fix it by a couple people last year. That didn't happen, but this didn't actually take effect until July 1st of this year for most condos. And as a result, we really don't have a concrete answer as to, are you just cut off today or a month ago, basically on July 1st, because it had been 8 years if you've been serving that long, or do you serve out the rest of your term? My opinion is, unless and until the government specifically tells us otherwise, or some lawsuit and DCA opinion, not just a state court opinion, but a district court opinion, tells us that you are cut off on that date, that's 8 years from the date you started serving, you continue until the end of your term, but you're not eligible to serve as a candidate in the next election. So that's about as clear as I can be, because no one's being clear with us as attorneys. And the statute is not really clear on this point either.
Here's an easy one. Brunson, Orlando wants to know, is a 3-person board legal? They don't say if it's HOA
You
or
think
condo.
that's easy. It depends on the size of the community. It depends on what the bylaws say. Is it legal? Yeah, it is. Is it appropriate? Depends on those factors. Do your bylaws say that it has to be 5? Do your bylaws say it has to be 7? If the bylaws say it has to be 7 people on the board and you've got 3, you need a receivership because you can't reach a quorum at any board meeting until you appoint someone to fill that extra spot so you can have a majority of the 7 serving on the board and making decisions. So is it legal? Yeah, it's legal to have 3 people on the board, but whether it's appropriate under your governing documents or based on the size of your community, I can't give you that answer without looking into it deeper as to your particular community.
This might be an insurance question.
Okay.
Karen in Orlando, is my HOA required to give me opportunity as an owner to pay my pro rata share of the annual property insurance in total so I don't have to pay the insurance finance charges?
If you're talking about your own insurance, that would have nothing to do with the HOA. So I'm presuming you're talking about the association's insurance policies, and the board gets to decide how they want to pay that off. If you want to pay them extra up front, great, but that doesn't guarantee that you will have, the benefit of not paying that interest. So the short answer is it's okay from a legal perspective if the board does not allow you to pay that off early. Listen, I would love to see every community association avoid all interest payments on every expense they have, but there's nothing that requires it in this instance.
This is from Crawley in Sanford. HOA considering adding amenities, i.e. pickleball courts, playground equipment, should they increase or change type amount of liability insurance coverage?
Oh, that goes in a different direction than I thought the question was going. Yes, you should have insurance not only for the increased risk of injury when you're adding sports courts, but you should really be talking to your agent about what additional insurance you're going to need to fully cover any damage that might happen to or on those new amenities. Because, for example, pickleball courts, okay, that's great. You've got your pickleball court. Maybe you can insure the court itself if lightning strikes and everything just, goes up in smoke, so to speak. Maybe someone's playing pickleball, they get hurt. You haven't had them sign a waiver. They have no warning that they might get hurt playing pickleball because, let's be realistic, lots of people are stupid and don't realize that sports can cause injuries. And then they're coming after you as an association, possibly as a director. Whether you've got any real liability is not really the question there. It's whether you're going to spend a whole bunch of money defending the association that you might get back or might not, depending on whether this person is actually collectible. Now, if you've got an insurance policy that covers this, which is the actual answer to the question, yes, you should be looking into that option. You're only paying your deductible, and that should be it, presuming that the claim is covered. So the short answer is yes, talk to your agent. They should be able to tell you exactly what it's going to cost. And frankly, what the additional insurance cost will be should also be factored in to what you are contemplating doing as to whether this is a good idea or not. Because, yeah, it may only cost you $100,000 to pave over certain areas, put in pickleball courts, add a bunch of umbrellas so that people can watch, whatever else you want to do. But if that's going to increase your insurance cost another $20,000 a year on top of the $100,000, you may rethink that. I don't think that'll happen. But if you're talking about several amenities and they're upscale amenities, that's not completely outside the realm of possibility, that kind of significant insurance cost increase.
This is from someone who's thinking about running for the board. He says, I know this is in our bylaws or our docs, but how do you decide how many board members you should have?
You just answered your own question. You got to look at the governing documents. Now, some of them will say the board shall be comprised of 5 people. At that point, there's no decision to make. If it says there's a range, so a lot of them, including a set that I just looked at today, says there shall be between 3 and 7 directors. The specific amount is to be determined by the board in advance of the election. Okay, well then the board gets to decide. One of the factors you should be considering when you're deciding how many directors to have is, can you get people to show up and vote at your meetings? Like I mentioned earlier, if you have 7 directors but only 3 show up, you're never going to have a quorum and the board can't conduct business. If you have 5 and 2 show up, same deal. So even in some larger communities, you might want to leave it at 3 just because that's the only amount of people you can get to actually be nominated and serve on the board. If you've got 2 more people that want to serve, maybe you increase that to 5. But first, make sure that you've got enough people that actually want to serve on the board before you start increasing the number of directors that seats are available for. There are a bunch of factors that I consider, but again, you've answered your own question. It's what do the bylaws say and what does the board think is feasible and what's going to benefit the association most? Those are the major factors.
Alan, your show always goes by so fast. I just want to tell you this. I'm looking at likes on, this is just TikTok. You've got over 5,000 likes on your show. That's amazing.
We're getting there, man.
Yes. Tell people how they can reach your office.
Sure. Well, again, my email address is as@kbrlegal.com. If you need to reach me directly, that's usually going to be the easiest way because sometimes I'm either on a radio show or out of the office at a CAI meeting. But the alternative way of reaching literally anyone in the entire firm is by phone. 1-800-974-0680 is the number for our front desk in Pompano. And that's the way to reach literally anyone in the entire firm.
And we must say, Jeff Rimbaum writes the most amazing articles, doesn't he?
He does. I'm a fan.
Yes. Alan's with us the last Thursday of the month at 5 o'clock Eastern time every month. Alan, thanks so much. You always do such a great job.
Thanks for having me. Thanks, everyone, for coming on.
I'll see you, my monthly friend. I'll see you next month.
All right. Have a good one, Steve.
Thank you, too. That's Alan Swartzide. He is a attorney at the K. Bender Rimbaum law firm. Folks, that's going to do it for us today. Whoa, that go by fast. Thank you for all the people who tapped on the screen, gave us a like on TikTok. Got over, I know, you know what? I don't know what's a lot, what's not. I see some people with 400,000 or 500,000 likes. Our show is really a niche show. We're talking about community association law. That's going to do it for us today. Thanks all for your participation. We'll see you tomorrow at 2 o'clock Eastern time. We're going to be doing our tax relief show. We'll see you tomorrow.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.